Good morning. My name is Manus Quigg. I'm from Brody's Sisters. I'm a partner in the contentious construction team, and I'm here to introduce today's seminar, which is number 2 in our NEC Masterclass series. Our speaker today is Chris Duffy, you can see on the screen. Chris is going to be speaking about compensation events under the NEC form of contract. It's obviously a very topical subject because 380 of you signed up for this today. So it's clearly, given that we're no longer in furlough, that's a huge number of people. There's obviously a lot of interest in this subject at the moment. As I say, this is the second talk in the series, the first being on the 3rd of February, which was on programming, equally well received and attended. If you are interested, and if you weren't logged on to that seminar and you want an opportunity, a link to the seminar because it was recorded, then please do get in touch.
I'm going to cover off 4 areas this morning. We're going to go through the basics for the compensation event regime before touching on notices. And then we're going to devote a bit of time to looking at our practical experience dealing with disputes under the contract before finishing up by offering some observations on COVID and how the contract has reacted to COVID. So most, I suspect, joining us this morning will be familiar with the compensation event regime in some shape or form. It is the effectively the composite regime under NEC to deal with both claims for additional time and money. And just as a point to note at the outset, where we have referred to clause numbers today and most of the observations, we're doing that under reference to the engineering and construction contract, and typically using clause references from NEC 3, albeit we do touch upon NEC 4 from time to time. Now, the effect on money is dealt with using the prices, and ordinarily you will be looking at the effect of the compensation event on the actual defined cost of the work already done, together with the forecast of the defined cost for work not yet done. And of course, that points up the first unusual feature of the contract and the compensation event regime, and that is the forecasting forward of the cost that you expect to incur on account of a compensation event. And that forecasting regime is absolutely central to the operation of compensation under NEC. In relation to time, it's much the same, but of course, planners the world over are quite used to forecasting forward on time. So that is not, I guess, quite so unusual a feature. But those of you who joined us a couple of weeks ago will have heard my colleague Louise Shields and David Falkenstein from BlackRock go through the programming aspects of this, and the fact that the NEC is relatively unusual in the sense that it tends to prescribe the analytical technique to be used by planners when looking at compensation events, and that's using the date shown in the accepted program and impacting the time effect upon that, which is, you'll have heard David take you through, was referred to as a time impact analysis. But the short point to begin is that it's a composite regime dealing both time and money, rather than perhaps the more separate regimes which emerge in other standard forms which deal with these things quite separately. Now, the CEs themselves are typically listed within clause 60.1, albeit there are various other compensation events identified in some of the secondary option clauses, for example. Those in the slides are not prescriptive. There are one or two others as well, but certainly X2 is worth noting because that's something we'll come back to later today, and that's change in law. Now, you can cater for additional compensation events, and in NEC 3, these ought to be identified as additional employer risks within the contract data part 1. There's then a bespoke tie back to those in NEC 4 where there's an additional compensation event listed, but in broad terms, the effect is the same. And quite frequently, although we don't devote a huge amount of time to this morning because colleagues are going to cover off these sorts of issues in a subsequent session, you will find that the NEC compensation events are routinely amended. So it's quite normal to find that coming to the contract from a contractor's perspective, the list of events has been narrowed somewhat, and certain events do not give rise to both time and money. And the most usual culprit there is 60.119. That's often, which is the act of prevention in a sense. Often what you find is that that has been amended to give time but not money. Now, it's the project manager who has a very central role in the operation of not just the contract, but in particular the compensation event regime. And I do cover off quite a number of features of the project manager's role this morning. They are tasked with assessing whether a compensation event has occurred, and ultimately, at least initially, the change to the prices and the completion date. I say initially because any decision by the project manager in that regard is reviewable by either party at adjudication. Now, the project manager's assessment will usually follow an instruction. They will usually notify the contractor of a compensation event, or alternatively, having been notified of one, they will instruct quotations. And so ordinarily there is an iterative process where the project manager is working with the contractor to arrive at an agreed price, ideally, and program impact for the event. Now, the contractor quotation should include both the changes to the prices and the delay to the completion date caused by the compensation event. And that delay should be mapped out as alterations for any remaining work on the accepted program. And again, those who joined us a couple of weeks ago will appreciate the significance of the accepted program, which is the contractor's program, which ought to be continually updated and submitted for acceptance through the project manager. And only with an up-to-date accepted program can you operate the NEC compensation event regime as intended. So that accepted program mapped out to cater for the effect of the compensation event can quite often be referred to as the Clause 62 program. Now, one interesting feature of NEC is the ability of the project manager to resolve any sort of deadlock around this situation by carrying out their own assessment. And the basis upon which they can do that is found in Clause 64.1. So there is a prescribed list there of bases upon which a project manager can take upon themselves to do the assessment of the compensation event, and I've listed them on the slide. Those familiar with the contract will recognise that in practice it is not difficult for a project manager who is so minded to bring themselves within one of those four bullets. So quite often the project manager will disagree with any quotation or assessment which has been prepared by the contractor, and that would be sufficient under the contract for the project manager to thereafter carry out their own assessment. And that's certainly an area that we do see some disputes. I'm going to touch upon some of the pros and the cons in that regard later. Now, project managers do need to be aware of some traps for the unwary in relation to the operation of the provisions, and I've flagged 61.4 and 62.6 in the slide simply because they are dealing with what are known as the deeming provisions, and that's where a project manager can be deemed to accept first that a compensation event has occurred, and then second, the contractor's quotation for that compensation event. And again, those who've worked with the contract will recognise that that iterative process that I described, where one contractor will notify and or quote. The project manager then has a period to acknowledge and reply. And if that process doesn't run its normal course and the project manager ignores or neglects to reply within the time limits allowed under the contract, then they can be deemed to have accepted the position. There is a fail-safe because ordinarily the contractor has to notify the project manager of that failure, and that failure has to continue for a further period of time. But nevertheless, it's another area that we do see causing practical issues on site and disputes. From the contractor's perspective, it's equally as important that they appreciate the notification requirements, and we're going to come on to those in slightly more detail in the slides that follow. And in particular, we need to maintain that updated, accepted programme. We covered off, the very real difficulties a couple of weeks ago that you can start to see where you don't have that accepted programme. And so it is absolutely crucial that contractors keep submitting that. So in summary, so far as the basics are concerned, the regime is intended to be the comprehensive remedy for claims for additional time and money for the events listed at 60.1 and those found in some of the secondary clauses. There is going to be an element of forecasting, and the element of forecasting on the price in particular is one of the more unusual features, and one of the features that often causes parties most difficulty on the job. There will be, in our view, certainly significant scope for the project manager to carry out their own assessment, whether the contractor agrees with that or not. And so both contractors and project managers need to be cognizant of that. And a dissatisfied party can refer any project manager assessment to adjudication. So they don't have the last word. The project manager role under NEC is not a role under which they are asked to decide on a final and binding basis these sorts of issues, as might be the case under other forms of contract. I want to cover off very briefly this morning notices. Notices are much heralded under NEC. I think most users of the contract do recognise that it places a greater management burden on the parties and the project manager than certain other forms, and that notice and communication are really sort of the watchwords for how you ought to use it in practice. But throughout the last year, and certainly fielding a lot of claims and giving a lot of advice around projects which have struggled, not just with the effects of COVID, but also the usual sort of issues that we see. It has been quite interesting to kind of remind ourselves just how much or how little some of the notice provisions do be operated by some of the parties here. Now, clause 13.7 is one which is, in my experience, often overlooked, and that is that a notification which the contract requires ought to be given separately from others. And because NEC does generate a lot of paperwork, it's very tempting for both contractors and project managers to almost bundle up communications and deal with them almost cumulatively. And obviously where parties are adopting a fairly pragmatic approach and operation to the contract, that might be permissible, but strictly speaking, the contract does not recognise that as a permissible way forward. So just be aware of that. Clause 16.1 is another interesting one, and this has been something that we have looked at quite a lot in the last year because of the situation with COVID in particular, and that's the early warning mechanism. And I think read shortly, more often than not, this is regarded as something or an additional hoop for the contractor to jump through. And in a sense, that's absolutely right, that the contractor is obliged to notify something which could increase the cost, could delay completion, and so on and so forth. And that early warning regime has not just in a sense found favour with NEC, but quite often these days many people will see a similar sort of regime taken into other forms of contract using schedule amendments. It's obviously something which has gained some attention, and those in the industry quite like the idea. But one of the, from my perspective, often overlooked aspects of the early warning regime is that it's a dual obligation. It rests just as much with the project manager as it does with the contractor. And of course, in relation to traditional contracts where there's perhaps very little, if any, contractor design, it might be the project manager who's first cited on possible changes to the works information and the like, given their relationship with the employer. And so there is something to be said for examining whether or not the project manager ought to be giving early warnings and the effect where they don't. Now, there is some teeth to the early warning regime, and that's set out at clause 63(5), which allows the project manager to assess a compensation event in the manner that they would have done had an early warning been given, where that hasn't been given by the contractor. So in effect, it's an attempt to try and penalise the failure to early warn. But again, one aspect that I would point up this morning would be what clause 61(5) requires of the project manager in that event, because what that clause points up is that when the project manager instructs quotations, which will be right effectively at the outset of the compensation event process, it's at that stage that they must notify the contractor of the decision that they did not early warn. So if the project manager doesn't notify the contractor right at the outset, then certainly in my view, they would have a difficulty later relying upon that failure come assessment stage. Now, I've placed in the slides that anecdotally, the failure to early warn and the idea that you can then be penalised come assessment stage is possibly more a theoretical than a practical issue, because ultimately it's asking the assessor to assess a hypothetical, a situation that would have emerged had the warning been given, and assessing a hypothetical is obviously always that bit more difficult, and it's almost always going to be capable of being challenged by your opponent. So it is perhaps something which hasn't received as much attention over the years, but it may receive far more attention over the next period because of the prevalence of compensation events which have been notified, either because of COVID or connected to COVID. Now, in terms of the underlying obligation to notify, again, that rests both with project manager and contractor, depending on which particular compensation event we are discussing. So for those which arise from the project manager giving an instruction, issuing a certificate, so on and so forth, then strictly it should be the project manager notifying the contractor that that's a compensation event and requesting quotations. So, an example, an instruction to change the works information should be issued by the project manager with a request for a quotation. Now, for everything else, the onus would be on the contractor to notify. And because of the terms of 61(3), which attempt to time bar late claims, it would certainly, in my view, be good practice for the contractor, if in doubt, to notify anyway. So irrespective of whether or not the project manager should but did not notify, if an event has occurred which the contractor believes is a compensation event, then far safer to notify within the 8-week period. And beyond that 8-week period, those familiar with the contract will be aware that there can be no change to the prices or the completion dates. The idea is that failure to notify within the 8-week period should be fatal to the claim. Now, for the project manager, we've covered off already the fact that you can have deemed acceptance of both the compensation event and the quotation for the compensation event. So the notification requirements are equally as important for them, because it's always a difficult conversation to have with your client where you're being told that the contractor has had an event both accepted and then a quotation accepted in circumstances where the project manager might not even believe it was a compensation event. And NEC 4 has sought to build on that deeming framework by adding to the accepted programme. So under NEC 4, it's now possible for the contractor's programme submission to be treated as deemed accepted where that has not been responded to timorously by the project manager, and the timescale there is set out on the slides. So in summary, on notices, there's obviously several requirements on the parties, in particular the contractor and the project manager, to communicate and notify each other. That ranges not just from early warnings, but also takes you into the replying to compensation events, the quotations, dealing with submitted programmes. And there can be fairly severe consequences for failing to adhere to notice provisions. So on the contractor's side, they can lose the rights to additional claims for time and money. And on the project manager side, they can be faced with having been deemed to accept assessments which they'd rather not have done. So always worth just recapping on what the contract asks of parties in that regard. Now, I want to go through some practical areas that we think work well and that we have found can create problems. And really the scene setter for this is that it's often said that NEC promotes good contract management, it promotes better practice. There's a degree to which we would probably agree with those observations. But then it's also often said that as a result of these things, there are far fewer disputes. That's not our experience. Our experience is that NEC generates as many disputes as any other form. What is true to say is that there's probably fewer reported decisions in NEC because parties must adjudicate first, and often, irrespective of whether they agree with all or some of the adjudicator's decision, quite often after that first round, parties separate out and agree their differences. So more often than not, a decision from an adjudicator will, in effect, resolve the dispute. And because of that, it will never see a courtroom. But certainly, our view is that the contract does generate plenty of disputes, and at any given time at the moment, I would find that certainly half the work that I've got on will be disputes on NEC jobs. Now, what works well? We think the notices and the timescales around the notices do work quite well. I'll come on to that. Also, some proactivity on the part of the project manager can be the difference between a job going really well and not. We're also going to look at some of the areas which create problems and try and offer up some tentative solutions to those. Tentative because we recognise we don't have all of the answers, but there's certainly some areas in particular around forecasting which we think could be dealt with slightly better. So in terms of the notification regime, having gone through that this morning, I think what can be safely said about that regime is that it does prevent fewer stale claims from emerging at and around completion. Because of the requirement to notify, to early warn, to deal with that all within 8 weeks of the event, you tend to find that if nothing else, parties are aware of what's going on in the job at the time. And the fact that there wasn't a dedicated final account process as well under NEC perhaps helped with that theme, because there wasn't that sort of set piece exchange penciled in for the end of the job at which parties could have a fresh battle on all of the prior issues. Now, with the NEC 4, a final account regime has been introduced. So it will be interesting to see whether that has an effect on people's attitudes. But certainly what can be said is that the notification regime under NEC 4 is no less onerous, no less detailed, than that under NEC 3. So the introduction of that regime should not transform parties into a situation where they are battling out the final account in relation to issues they should have ventilated sooner. And the timescales, I think, around that are equally important. They are very challenging. There's no doubt about it that if you're a project manager, you have a week usually to agree or disagree with whether something is a compensation event. Now, that is an extremely challenging timescale. Yes, there's further time available when you then get into the assessment of that event and where the job and everybody's getting on. You will find that parties will work together to give each other that additional time. But certainly at first blush, there are very challenging timescales for parties to work through in order to keep the show on the road. And the role of the project manager is absolutely crucial to that. And we can often find that the really good jobs have been really well project managed. I know it sounds trite to say, and it ought to be obvious, but the role of the project manager can really add a huge amount of value by breaking deadlocks and keeping that show on the road. And one of the really interesting things from my perspective is the management of the project manager assessment process. We covered earlier that it would be quite straightforward for a project manager dissatisfied with a contractor quotation to immediately reach for clause 64 and do their own assessment. And sometimes that will be absolutely necessary if they judge, one, that the contractor's just never going to get this right no matter how often you try, and two, the priority for the job must be to keep moving. You know, this is acting as a distraction. I just need this moved on. But at a critical phase, it's better that I just crack on, make the assessment, and keep matters moving and keep everybody happy. But that's a judgment call, and I think it's a really interesting one, because if you're the project manager in that situation, you need to be aware that the minute you do your own assessment, that assessment can be revisited at adjudication. So if you get it right, great. But if you don't and the contractor's unhappy with it, then they can have a second go. And by that point in time, they might know the actual cost. And there's been authorities in the last couple of years which point up that a decision maker shouldn't ignore actual cost, in spite of the fact the contract imagines that we should all be forecasting. Now, faced in that same situation, the project manager might not reach initially for their own assessment, but could go back to the contractor, having rejected their quotation, and sought a revised one. And a good project manager can perhaps influence the contractor to bring forward a revised quotation, which is more along the lines they are thinking. And if they can elicit that revised quotation from the contractor and they accept that, well, the contractor's bound by that, because that's the contractor's forecasting quotation, and that's not later revisited if found to be wrong. So there's definitely a bit of a dance around whether or not to go for a PMA or whether or not to knock back a contractor quotation. And that's certainly one area which project managers who really understand the contract can add a huge amount of value. So what can create problems? The forecasting regime has always created problems. And I think it's a natural enough issue that you've got the contractors on one side of the ledger who will always want to err on the side of caution. So they'll build in, risk allowance into their quote. And I don't think they can be criticised for that. And then on the other side, you'll have project managers who would probably rather wait and see. They don't want to buy off a quotation if they think that's going to expose the employer to an overly generous assessment, which will give the contractor a windfall. And so there can be a natural temptation to wait and see exactly what the impact of an event is going to be. And 63 stop 6 is quite often one of the key battlegrounds in that regard. That clause allows the contractor to, within their assessment, build in the risk of any risk which has a significant chance of occurring and which is their risk under the contract. And quite often contractors will build in, a fair bit of risk into their quotations using that clause, and that's often a really fertile area for disputes. Another issue that can create problems is the accepted programme falling out of use, and that was foreshadowed a couple of weeks ago in the first session we did on this, and the problems that can create. And it's especially difficult where you've got multiple CEs building up, because once you start to have an accumulation of them, going back and dealing with those retrospectively can be a real challenge. Now, in terms of solutions, one of the, it seems to us, key areas which the project manager has available to them to try and effectively deal with some of the tension which would otherwise emerge with the forecasting regime is to state assumptions. And if they state assumptions for the contractor to price against, then that does allow the parties to revisit the assessment of that compensation event later where those assumptions turned out to be wrong. And I'll be interested to hear from project managers on this, because certainly my own experience, but then again, I absolutely confess that the nature of what I do means I only see the bad jobs. But my own experience is that assumptions are not used anywhere as often as I would expect them to be. They are intended for use where the effects of a compensation event are too uncertain to forecast. So a classic example of that would have been COVID last year in March and April, because none of us had a clue in March or April last year what the effect of that was going to be on jobs. And even so, I saw very rarely good examples of assumptions being used to deal with that sort of issue. So I do think they are one area of the contract which are perhaps slightly underused, and which could create a bit of additional protection for both project manager and contractor around this. Now, and I say project manager because often it's their, not reputation, but certainly it's them who are going to come under pressure from the employer, and they perceive that they will come under pressure from the employer if they allow a contractor quotation through which is overly generous. So a way to sort of protect against that criticism, in my view, is to state assumptions and to better control that process. And I think historically there's been perhaps a bit of a myth that that correction would only ever operate in one direction. It would only ever operate in the contractor's favour, but that's not the case. So if the project manager's assumptions turn out to be overly generous to the contractor, then upon correcting those, the prices can be reduced every much as they can be increased. So we've put the clause number on the slide there, which is 63/10 for options A and B. It's 63/11 for main options C and D. And this, in my view, a bit like the discussion around the project manager assessments a couple of slides back, it's understanding the distinction between incorrect forecasts and incorrect assumptions, because an incorrect forecast can't be revisited. So if the contractor prices their quotation and that turns out to be overly generous, that's the contractor's to keep if that's accepted. Whereas looking at the situation with assumptions, if those turn out to be overly generous, then they can be revisited and the situation can be remedied. Now, in relation to the accepted programme, colleagues offered some thoughts on this a couple of weeks ago, and I can probably do no better than they did, which is that it's always going to be a key area, because there's a natural reluctance on the part of project managers to accept contractor submissions which they deem unrealistic, and because realism will be subjective, it will be each of the parties and their own views. There's always going to be that debate. But if you are the contractor, then I think the best advice is to continue to submit those programs each month. do not be discouraged, disheartened by the fact that you're not getting them accepted. Do keep submitting them, because if you end up in dispute resolution and dealing with the effect of a compensation event on the accepted programme, if you have at least submitted a programme for acceptance as you have been required to, then you've got a positive story to tell in that dispute. One of the first things you'll be asking the decision maker to do is to judge whether or not that programme you submitted should have been acceptable to the project manager. Whereas if you haven't submitted anything, then that very first part of your story is missing, and you're on the back foot. So always better to be producing programmes on an updated basis and submitting them for acceptance. So in summary, in relation to the sort of practical issues that we are seeing, we don't doubt that the compensation event regime does promote the earlier resolution of project problems. It doesn't prevent parties getting into a dispute about them, but it certainly does bring that dispute to the fore a bit more rapidly than other forms of contract. But undoubtedly, parties need to invest a substantial bit of time and effort into keeping the show on the road. There is a huge resourcing burden on contractors and project managers in particular. It's a real team effort, and that is still, over a decade after NEC 3 came into popular use, that is still something which we see overlooked by parties. It's just the sheer resourcing burden it places on you. NEC 4 has made some tweaks to the regime that the deemed acceptance of the accepted programme one positive, but it's largely tweaks around the edges rather than major change. Going to finish with thoughts on claims for COVID-19. I think most dispute lawyers in the last year have probably devoted a fair bit of time to looking at this, and it's been a very movable situation, as it's been for many others, where as more guidance, as more legislation, as more activity has developed, how contracts have reacted to that has tended to develop with it. So in our experience, NEC has been able to flex pretty well to deal with COVID-19, and I've separated out what we see as the more conventional treatment from perhaps other routes and other areas where parties have looked to for relief. So certainly the conventional treatment has been through the kind of operation of the twin clause 19 and clause 60.119 process, and that's acts of prevention. And then there's also been X2, which is change in law. So where that has been selected, because that's obviously doesn't apply by default, but where it has been selected by parties, we have seen that used successfully as well. Now, the clause 19 route, the contract, and we've produced in the slides there an extract from the clause, and it's just worth noting that it must be an event which stops the contractor completing the work, or stops the contractor completing the works by the date shown on the accepted programme. So you need to show that it's going to cause delay, not just additional cost. Now, for the most part, parties were absolutely able to show that because of the lockdown in Scotland and the very lengthy delay thereafter, while we went back up through the Scottish Government roadmap to reopening business in the summer. But it is worth just reminding that you need to show delay, not just additional cost. Now, X2 would be engaged from the date, according to the contract, there has been any change in law. And more often than not, in that regard, we are seeing parties settle on or around 21 April 2020, and the introduction of the second set of coronavirus regulations in Scotland. And the reason for that is those were the regulations which required any business operating in the pandemic to provide for social distancing. So those tended to be the regulations which struck at contractors and the operation of their sites. So what we've seen is that contractors have typically been applying for relief under one or a combination of these clauses. And where they have been, there has been very good examples actually of all parties working together to try and bring a bit of certainty to a very uncertain situation. So we are aware anecdotally of some good practice there. But perhaps of more interest to us have been the cases where these clauses either haven't been available or have been heavily amended, because certainly clause 60.119 in particular can often be amended to give time but not money, and X2 being a secondary clause may not have been selected. So in that sort of situation, we've tended to notice that the starting point in our view is probably clause 19 again. And if I just go back to the extract here, you'll see that the wording of clause 19 is that where the what I'll call act of prevention has occurred, the project manager gives an instruction. So that's, in lawyers' terms, that would be regarded as fairly mandatory language. That is something which the PM must do. And so, irrespective of whether the sort of sister clause 60.119 has been amended, it does certainly seem to us that under clause 19, the onus is on the project manager to do something. And often where parties start to fall out is exactly what that something is. So a couple of options and a couple of areas that we have seen some movement are, first, that the project manager can put a stop to the work under clause 34 stop 1, which in turn would be a compensation event under clause 60.14. And certainly we've seen contractors argue that as at the point in time when the Scottish Government were instructing society to largely close down, including construction sites, that a project manager really ought to have been giving that sort of instruction. And I think that's a fairly good argument, actually, and certainly one we've seen run by a number of contractors in relation to this contract. Another is that the project manager could give an instruction to change the works information. And again, that would be a compensation event under 60.11. I think the issue for contractors there is they need to be really quite clear on what they say that instruction should have been. If we do get into that sort of discussion, but certainly it's worth bearing in mind that the works information is not just the documentation which describes the works, but it's also the documentation which describes any constraints in the work. So if there are additional constraints, then there is an argument that those ought to be inserted into the works information, and that would be a change. So those are areas we have seen contractors explore in relation to claims for relief where there has perhaps not been the more conventional route through 60.119 and or X2. And just summing up in terms of the sort of final slides on this, I think what we've seen, I do want to stress that it's not all been bad. Whilst we only do tend to see the bad jobs, we are working with those in the sector who are involved any range of them, and some of them have gone well, some not so well. So we do hear good practice too, and there undoubtedly has been really good examples of parties dealing with the COVID claims emerging under NEC really, really well. But I think it's fair to say there has been a natural reluctance for project managers to take steps which invite, as they see it, claims for compensation events. And so whilst it does seem clear that it would be the project managers sort of tasked with giving an instruction under clause 19, I think it's been far less clear, the extent to which that has been exercised in favour of taking a positive step. More often than not, it was left to contractors to decide to come off site at the end of March last year, and actually properly regulating the basis upon which they left site and so on and so forth became, really quite difficult. And, for all the exchange of paperwork about it, a lot of jobs ended up fudging it. But in fairness to all of those involved in that process, including the lawyers, it was a fast-moving situation. And to be honest, quite often, I think parties took the view that the easier decision to make was to make no decision at all. And one of the interesting things about all of that is looking at the contract, it seems to me anyway that it's really actually well equipped to have dealt with this. The assumption regime, cries out in this sort of situation to be used, given it's there precisely to deal with a situation where it's not possible to forecast the effect with any real certainty. And so, the assumption regime is one aspect which I think could have been used more frequently by the parties. And whilst it's for the project manager, strictly speaking, under the contract to state the assumptions, we know that in practice, good dialogue with the contractor might be or might cause a series of agreed assumptions. So often a contractor will want to state their own assumptions in their quotations, and with a bit of dialogue with the project manager, what you might find is that there are an agreed set of assumptions which could have been priced and which would then give both sides the protection which they can revisit. And the final point I want just to leave you with is one thing which has emerged as well through the last year, is that it's probably shone a bit of a light again on exactly what the role of the PM is under the contract. And I've got a huge amount of sympathy for PMs because they are in a really, really difficult spot. They are often engaged, or almost always engaged, by the employer. The employer will have a view to selecting a PM which they believe will best protect their interests. And from the PM's perspective, when they look to things like the guidance notes which tell them how the contract operates, they will take comfort from those too, which point up that PMs are expected to act in a way which protects the employer's interest in certain respects. So there is all that on one side, but then on the other side of that coin is the kind of body of case law which is built up, where the role of a independent construction manager has been examined. And that sort of case law points up that project managers who exercise a decision-making function have to act both independent of the employer and impartially. And so there is a real, I think, tension here between those who are being asked to operate in this role and act in the best interests of the employer, and the cases which have started to develop in and around this area, pointing up the need to be really independent and impartial. And perhaps that's one area which we all can have a bit more of a look at and re-examine as we go forward. So in summary, we think the contract has responded relatively well to COVID-19. There are conventional routes under 60.119X2, and there's been really good examples of those being operated effectively. But This sort of event has understandably also probably pointed up and stressed those areas of the contract which already cause some tension or go unused. It has really stressed the forecasting because none of us knew where we were going to be this time last year. It has pointed up, certainly for us, that assumptions are not used anywhere near as often as perhaps they might be. And it's, I guess, just reiterated the importance of project manager role and exactly what's being asked of them in this sort of situation. And I think over to you, Manus.
Thanks very much, Chris. We've had a series of questions come in. It's fair to say I've got a few pen pals over the last hour. I've been messaging people back. First question is actually interesting. Some of them, quite a few of them, are based on the point you raised about the difficulties around the PM role. And question number one: if a project manager is refusing to notify a compensation event to a contractor at the point of issuing a PMI, is the contractor still required to issue an early warning notice? And the message goes on to say, this is something the project manager has requested us to do. However, early warning notices are looking for something that may increase the prices, etc. And in my opinion, a look ahead mechanism. The issuing of a PMI is the instruction to proceed with whatever the PM is instructing. Therefore, no mitigation measures can be put in place as the PM has already told you what to do, how to proceed. So the question is the PM, is the contractor in that situation still required to issue an early warning notice?
I think that's an interesting one. The requirement to early warn doesn't just apply in relation to compensation events. It's anything which could have an effect on and effectively on the program or the pricing. So, to my mind, there is an obligation on the contractor to notify that event, irrespective of whether or not the project manager agrees that that's a compensation event or not. Now, the whether the failure to notify from the contractor in that sort of situation, which arguably would be a breach, actually causes any loss, is a separate issue. But no, the terms of clause 16 would require early warning of any event. And I guess I put the question almost the other way around. What's the downside to the contractor in making that notification? It strikes me that it's always better to act on that side and make the notification if in doubt.
Thank you. Next question. In clause 64 stop 1, which is the clause that says that the project manager assesses a compensation event and then goes on to list the 4 bullet points. For example, if the contractor has not submitted a quotation and details of his assessment within the time allowed. So in clause 64.1, is it the case that the PM may assess the compensation event or must assess the compensation event if any of the 4 bullet points have been met?
So yeah, they just need to find one of those grounds. So they just need to bring themselves within one. And normally it will be because they just don't agree with the way in which the contractor has prepared their quotation. You know, obviously if there's an easy ground to turn to where the contractor just simply failed to do it entirely, that's very straightforward. More often than not, we'll see it's because having received something from the contractor, they disagree with it. Now, that's I think a far more interesting question, and you know you could spend an hour discussing the rights and wrongs of the project manager rejecting the contractor's preparation of a quotation, because there's certainly one school of thought that any project manager rejection on that basis should only ever be looking at the actual mechanical makeup of the value placed upon it rather than the contractor's pricing assumptions.
Yeah. And I think that question in part is driven by the wording of NEC itself, because it says the project manager assesses a compensation event if it doesn't use the traditional SBCC wording, which would be must assess, or where it gives it sets it out as an obligation, probably is where the questions arises from as well. Next question. In a previous program seminar, it was noted that the contractor could or should make assumptions in their compensation event quotation. However, if the project manager refuses to state assumptions under 61.6, which we were speaking about earlier, and the contractor includes assumptions and clarifications in their quotation, will those assumptions or clarifications have any standing, or does the contractor just need to price the risk regardless of how absurd or unforecastable this may be?
Yeah, I've got real sympathy with that question, and I wish there was a really straightforward answer to it. I absolutely agree with what David Falkenstein said 2 weeks ago, which is what the question is alluding to, because he suggested that a contractor should try and state some assumptions within their own quotation to give them the right to revisit that situation down the line. And I think that is best practice. And I actually think that where they do that, there will be a reasonable argument before a decision maker that they are permitted to look at that again. But strictly, if you are adopting a very literal view of the contract, it's only the project manager who has that right. So the focus of that question is absolutely right. Do they have any standing? Do they have any real bearing upon matters? And the reality is it would be up to the adjudicator to decide. But again, I turn it the other way. If you're the contractor, what do you lose by doing that? Because I think you should price all of the risk that you can see. But if you break that down and break that price down using a series of assumptions, I struggle to see how they can be any worse off. So it will always preserve that right to make that argument later.
Okay, thank you. Next question is, the contract makes no reference to wait and see or retrospective analysis of time impacts of the compensation event. If a project manager uses hindsight and says that planned progress on an unaccepted program ended up not being achieved, and so rejects the impact of the compensation event, how does the contract deal with that other than by reference to a dispute?
Yeah, no, I mean that comes up time and again, because of course what the contract envisages is that it will be dealt with using a time impact analysis at the time, so that we'll all be forecasting forward, and then we're kind of sort of bound into that rather than the actual progress ultimately achieved. Now, the reality is if that hasn't been done at the time and we are dealing in a retrospective analysis, I think it would be quite a brave decision maker that ignores the facts, that ignores actual progress, and that goes as much for cost. Once it comes before a decision maker, what the Northern Ireland Housing Executive against Healthy Buildings case from 2 or 3 years ago looked at was just how on earth a decision maker seized with assessing compensation events years after the events in question had to deal with them. And what the court was saying was, it would be a fiction to ignore what actually happened, cost actually incurred. And they dressed that up by reference to what they called the best evidence rule. But for practical purposes, I think that's what you'd be saying to adjudicators. Why grope around in the dark when you can see what you need?
I remember having that years ago on a dispute regarding unexploded ordnance on a site, where the contractor came back afterwards and asked to price for risk, and the risk was the risk of the bomb exploding. But the point was the bomb hadn't exploded. So it's your very point. Okay. A contractor has
example. That brings it to life. I may use that example in the future.
Blow up, yeah. The contractor has submitted 4 compensation events with their final account. There was no early warning notice for any of these. One is for a significant amount of money. Just wondering the best way to go about this.
Well,
somebody's late notification, I would suspect, if it's submitted with the final account.
There'll be certainly a couple of areas to explore, and just keep the contractor honest, if we can put it like that, on that. One will be, should they have notified you sooner anyway? Because if it's not an event which originated from a project manager instruction or so forth, there is the 8-week cutoff, which the contractor should have abided by. If that doesn't prevent the claim from proceeding, and arguably it shouldn't prevent assessment of that claim by the project manager. They should still assess it. It's just that the employer would then have the right at adjudication to say that that assessment's all terribly interesting, but the claim had been cut off. But no, for if the 8-week cutoff can't come to the sort of rescue, then it would be looking at the effect of that failure to early warn, and you'd need to be, this is where you are into hypotheticals, and decision makers are far more suspicious of hypotheticals, as we all are, and you would need to have a really good story. Why do you see that failure to early warn has made the difference here? What would you have done differently had you known about this claim sooner? How would you have avoided the time and the cost of this claim? How would you have arranged affairs differently? If you've got a good story to tell around that, then absolutely explore the failure to early warn.
Okay. If the project manager's assessment of a compensation event fails to foresee or forecast the effect on completion beyond the immediate effect, can the PM's assessment be challenged with adjudication, or should the assessment be changed by the PM at a later date when asked, or is the compensation event fixed?
Yeah, I mean, I think there's a legal and practical answer to that. You can review adjudication, and often the knowledge of that fact should be enough for the PM in discussion with the contractor to consider whether they ought to review it themselves. But once that it's the concept of implementation under NEC, like once that assessment's been notified by the PM and that completion date's been changed, that compensation event is treated as having been implemented. And there is a real question around the extent to which the PM can then, off their own back, go off and look at that. So, but it's another reason, had it been quite an uncertain event with a lot of movable parts and had assumptions been stated, then you could have revisited it if one of those assumptions turned out to be wrong. But where it was a straightforward PMI without assumption, then no, strictly speaking, the contractor's recourse is to review it at DRP. But you'd hope that with a bit of sense, if there was an acceptance that the earlier assessment had been ungenerous, that they could have worked out a way to avoid that.
And next question is related. When notifying a correction to an assumption, are there any timescales related to these? For example, would they need to be notified within a certain number of weeks of it becoming clear that the assumption was not accurate, the original assumption? Also, does the contractor have any right to reject the correction of the assumption?
Yeah, so the notice for the correction is to be given by the PM. So the contractor shouldn't lose, so if an assumption turns out to be wrong, say it was assumed that lockdown would last 6 weeks back last March, and it lasted 12 or whatever, it would be for the PM to notify that correction. So the contractor shouldn't lose the right, having sat back and waited for that. But then the contractor can absolutely dispute the effect of that correction. So the correction is just the mechanical basis on which the parties are then free to revisit the assessment itself. So the correction gives rise to a fresh compensation event, which then gives rise to a fresh assessment. And at that stage, parties are free to make their arguments, make their assessments, and revisit it.
Okay. I think there are still a number of questions, but we'll contact those who have asked them direct and respond if that's acceptable, because they are still coming in and we could be here all day. So if that's okay, if we can just leave it there. And thank you very much, Chris, for your presentation. Thanks to everybody who logged on today. As I say, this is seminar 2 of a 4-part series. The next one is on payment and valuation on the 3rd of March. And then on 16th of March, we have common Z clauses to conclude the series. So thank you very much, everybody, for your time today. As I said at the start, if you are interested in getting a link to the recording, this is a recorded event. If you're interested in getting a link to the recording of the previous event on programming, please do get in touch. And thank you very much for your time. Thank you.